Hi, everyone. We're going to get started. There might be some people still trickling in, and that's fine. It was a short, kind of compressed lunch. Welcome to the Law Reform and Access to Justice and a People-Centered Justice System panel. I am one of your co-moderators today. I'm Leah Howie from the Law Reform Commission of Saskatchewan and also president of the Federation of Law Reform Agencies of Canada. And my co-moderator with me today is Nye Thomas, who will then introduce all of our speakers as they get ready to go. Okay, go ahead.
Hi, I'm going to tell you a little bit about our organization, then we'll pass it over to talk a bit about the day, and we'll pass it over to our presenters. FOLRAC is the Federation of Law Reform Agencies of Canada. We represent independent law reform agencies across the country. So we aren't part of the profession, we aren't part of government, we aren't part of any stakeholder group. You know, our reason for being is to provide an independent public interest, collaborative, thoughtful, principled analysis of contemporary law reform issues. And you'll hear from the presentations today that our work covers quite a sweep. We've really got two sets to our work today. First, we're going to hear from three commissions talking about a contemporary piece of law reform work they're working on and how it contributes to and is influenced by access to justice principles. Then we're going to try to lead a bit of an interactive workshop where we will be sharing and discussing, inviting for comment, some draft principles we have put together, trying to incorporate access to justice principles in the mandate and project selection and approach that as organizations we take to our work. So let me introduce our panelists quickly. To my right, we have Shauna Van Praw and Amelia Souffrant from the Law Commission of Canada. Then we have Sandra Peterson and Laura Buckingham from the Alberta Law Reform Institute. And at the end of the table, we have Alexandra Pasca and Pierre Noirot from the Quebec Institute of Law and Justice Reform. Their bios are in the materials, not going to cover that. And I will, in fact, just pass it off to, I believe, the LCC is going first. Excuse me, Alberta's going first. Yep. So this is for the slides. So Sandra, you and Laura are up. Thanks.
Thank you. So I've been going through and doing a lot of background reading on law reform lately, and this is kind of my touchstone quotation for the moment. So, what's the point of doing law reform if it doesn't have any impact? So Laura and I and a couple of colleagues in the audience, we are from the Alberta Law Reform Institute. I myself have been at ALRI since 2002 in 3 different roles and 4 strategic planning sessions. So in the last one, we finally settled on our mission is to improve the law of Alberta, and our vision is for just and effective laws. Now, for a long time, I wasn't quite sure how independent law reform agencies figured into the access to justice picture. I mean, one of the things is we are not frontline service providers, so we don't see clients, which is where a lot of the focus on access to justice has been. So how do we justify what we do as improving the law, or so hopefully improving access to justice, which is important not only for the outcomes that we want our work to have, but also to maintain funding, because typically we are funded from the same pools as access to justice. So having been doing law reform for over 60 years now at the Alberta Law Reform Institute, there are a number of patterns that emerge in the work that we do, and I will just read this out because it looks like it's a little bit small. So the issues that we address are typically problems of the form of the law, its substance, or its application. So in terms of form, the law is unclear, inaccessible, or needlessly complex. And I'll just give a quick example of that. We recently recommended that there should be electronic notice for landlords and tenants. Our legislation did not refer to email. It did have a 47-word explanation of something that we think is a fax machine. So needlessly complex explanation. That then also goes to some of the problems of substances, so there's a gap in the law or no law in an area. It didn't deal with email. The law did not reflect advances in society or technology. I think only the medical profession still uses fax machines. Landlords and tenants, not so much. Could also be that the law does not achieve its purpose or no longer serves a valid purpose, that it raises a conflict with primary law or principles of good lawmaking. That's a little bit of Alberta shorthand for saying we think it violates the charter, but we don't want to raise that red flag too high. Or the application of the law itself leads to results that are unfair, inconsistent, or unintended. So if those are the types of problems that we're taking on, this is what we hope we achieve when we improve the law. So hopefully if the law is simpler, it's easier to access. If the legal system promotes modern norms, hopefully that increases access to justice. And, I think you'll get the slide set later, but I want to leave lots of time for my friend Laura, who's going to walk you through one of these examples. And also, over the course of our history, we've been fairly successful at having our recommendations implemented, because that's where, essentially the rubber hits the road. That's where the change actually happens. So we have a very significant track record of 65% of having our recommendations implemented. So that means that over 70 pieces of Alberta legislation have been adopted or changed as a result of our work. Also, sometimes change happens very quickly. So you see that we've got average of, roughly 40 some months, but there's also I gotta check this one because I know there's probably data nerds in here. The median time of 20 some months. So that's less than 2 years. So what that means is some change happens very quickly, but also that the average is drawn up by some change that takes a very long time. So our current record now is 25 years for getting something implemented. But then it was implemented because that change was still needed. So I'll turn it over to Laura now to walk you through a case study on change.
Thank you. Good. So I'm going to talk a little bit, as Sandra said, about an example that illustrates what the impacts can look like. So we saw that previous slide that had all the impacts. Any of these things we could consider an aspect of access to justice. But I'm going to focus maybe just on a few of them. So several people at this conference have already mentioned that access to legal services or legal processes or courts is not necessarily the same thing as access to justice. And so that's a point that I want to pick up on. I'm going to talk specifically about the example of Alrie's work in family property law. And I'm going to go back quite a few decades for a brief origin story. So some of you may be familiar with the 1973 Supreme Court decision in Murdoch and Murdoch, but just as a very quick recap, I could use all my time talking about this case and how it still has ripple effects today. But the Murdochs were a ranching couple from southern Alberta. They both worked on and off the ranch. They pooled their earnings to buy land. And when they split up, the land was in his name was on the title, so he kept the land. I said they split up, and that kind of obscures what happened, because actually he broke her jaw, and when she came back from hospital, he had changed the locks. Anyway, she thought she should be entitled to a share of that land, and she made a claim. And here, she had some good fortune because she had a lawyer who represented her for free. And that lawyer represented her at trial and an appeal. and ultimately to the Supreme Court of Canada. But at every level, she lost, and she ended up with no interest in the land. So that's an example where someone had access to legal services, they had access to courts, it was timely decision-making by a lot of measures, but I would argue that she did not have access to justice because the law itself was unfair. Good news is we can change unfair laws, and that's an area where law reform can come in. So ALRI and other law reform agencies across Canada were involved in proposing law reforms that address this. In Alberta, ALRI's project actually began before the Murdoch case reached the Supreme Court. ALRI published recommendations, and by 1978, ALRI had a Matrimonial Property Act. And similar things happened in jurisdictions across Canada. So across Canada, by the end of the 1970s and still today, there's legislation that ensures that each spouse leaves a relationship with a share of property that they acquired together. Too late for Mrs. Murdoch, unfortunately, but had a major impact on many people going forward. I'm just going to take a quick moment here. Whatever you may have heard about Alberta or whatever you may know about Alberta, there's also a long tradition in Alberta of people who have stood up, individuals who have done hard work and brave things to seek equity for themselves and others. And I want to acknowledge Irene Florence Nash Murdoch Justperson, who was one of those people. And in acknowledging her, I also want to acknowledge the people who came before her and who came after her, including the people who are doing that work right now. All right, so skipping forward decades, we get to continuing work of law reform. And in an earlier session, I saw a slide about a bridge in Northern Ontario that was built and then broke and had to be rebuilt. And I love that metaphor for laws. So the Matrimonial Property Act, we've had it for years. It applies to married couples, but there's a major gap, or there was a major gap. It did not apply to unmarried or common law couples. And of course, there were common law couples all along. I'm not going to go into a long list of cases. There was evolution in case law that partially filled the gap, but it helped those who had access to legal services and courts. For those without access, they were often in the same position as Mrs. Murdoch. So as the number of common law couples increased, the problems affected more people, and that's what brought this to our attention. Now, changing the law can sometimes help with access, and we heard an example earlier today about child support guidelines. Family property law is another place. There's lots of different ways that changing the law can help with access, but one way is presumptions or simple laws or formulas that are easier to apply and actually keep people out of litigation and out of court. There's a whole bunch of interesting things we could talk about here about, the nitty-gritty of law reform and how we get from sort of general recommendations. Other people do great work sort of analyzing problems and making recommendations about them. And then sometimes that has to be translated into specific laws that can be changed and specific proposals for how to change those laws. Again, I could talk for a long time about that. But I want to move on because I have two questions that I want to pose that I think are interesting and difficult, and I don't have the answers. One of them is about when we're proposing changes to the law. So say we've gotten to the point where we know which law we want to change and we know that we want presumptions or formulas. Now we have to figure out which ones. And the question that I think we need to ask as law reformers and as people in the legal community is, how do we know what is just? And I certainly don't have all the answers, but I do know that part of it has got to be talking to the people involved. So in a conference about data, I need to have at least one slide with a chart So here's my slide with a chart. You may not be able to see the details, but it doesn't really matter. My point is just that as part of our project on family property, we did public opinion research. We commissioned questions on a survey. And so this is just like a small glimpse of results from that one question. We do a lot of kinds of consultation. So this is just one part of like many different modes of consultation that we used on just this one project. But the interesting thing that I want to raise here that we've observed in this project and in others is that we often see a big difference about ideas about what is just when we talk to lawyers or people involved in the legal system and when we get this kind of public information. So if I just ask the people in this room what is just, and I know many of you are like directly involved in working with communities and working with people on the ground and working with the people directly affected, but I bet I would still see a difference. So it just kind of reinforces the importance of that input. And then the other interesting and difficult question I have comes sort of at the end. So cutting the story short, we did a whole bunch of consultation. We came up with recommendations. We published a report. It was implemented. Alberta now has a Family Property Act. But then my last question is, how do we know if law reform has been successful? And especially when we're talking about the justice in law reform, how can we evaluate that? And that's something that I certainly don't have the answer to, but I would be very curious to have conversations, and maybe that's part of the conversation we can have today. And then very briefly, I just want to mention our current projects because these are other conversations I'd be very interested to have. So we're working on a project about residential tenancies. I'd love to talk more about that. And we also have a project about voice of the child in family court matters. So thank you.
Okay, thank you very much. Is this on again? There we go. Thank you very much to Allery. Now we will move to IQRDJ. Thank you. Maybe pass the slide thingy over.
Merci. Alors, ça va donner un peu suite, mais dans une autre perspective, parce qu'on travaille à l'Institut québécois de réforme du droit et de la justice, là, qu'on représente ici, comme Sandra présente, et puis l'Institut qui est en Alberta. On travaille, nous aussi, sur des législations particulières dans lesquelles on essaie toujours de voir quelle place les citoyens peuvent prendre, comment faire que la loi soit faite pour eux. Mais on est obligé de reconnaître que dans certains cas, changer la loi, c'est difficile parce que le système juridique et le système de justice lui-même n'est pas nécessairement construit pour intégrer ou tenir compte des personnes. De sorte que de temps en temps, il faut avoir des projets, je dirais, plus globaux que des projets de nature législative, s'engager dans des processus qui abordent le système de justice, le système juridique, dans une perspective qui, elle, inclurait les individus, inclurait les personnes. Et la meilleure façon d'y arriver, c'est de les inclure dès le départ. Et c'est à l'origine du projet sur les États généraux, sur le droit et la justice qu'on a engagé, dans lequel on s'est engagé en 2025, en novembre, et puis qu'on poursuivra pour les 2 prochaines années. Alors, je vais parler d'abord rapidement de ce qu'on fait, mais vous allez reconnaître ce que font d'autres commissions du droit, la mission de l'Institut, les projets d'activité et activités actuelles, mais surtout les États généraux là, sur lesquels on va s'engager ou dans lesquels on est engagé déjà et dont on parlera un peu. Alors, notre mission, évidemment, c'est une mission qui ressemble à celle des autres commissions du droit. C'est qu'on essaie de réformer la législation de manière à adapter la réalité du droit à l'évolution de la société elle-même, de manière à ce qu'une forme de mise en phase soit continue entre les lois qu'on propose qui viennent réguler des rapports sociaux qui, eux, évoluent de façon continue. C'est le grand défi, hein, vous savez, du droit, d'être pertinent, c'est-à-dire de réguler ce qui doit être régulé en fonction de l'évolution sociale. Alors, on est fondé, nous, sur deux grandes approches. La première, c'est la recherche. La deuxième, c'est la participation. Tous les projets sur lesquels on travaille sont fondés sur ces principes-là. d'abord regarder ce qu'on peut apprendre en étudiant dans des perspectives interdisciplinaires la réalité du droit qu'on observe et qu'on pourrait éventuellement modifier, et faire participer les acteurs les plus directement concernés, les citoyens, dans certains cas des acteurs plus spécialisés, dans ces réformes-là. Et puis, ça a amené à un ensemble de projets de recherche qui touchent des aspects différents de la législation, que ce soit l'encadrement d'intelligence artificielle, que ce soit la justice en ligne, la justice familiale, la justice municipale, quand c'est tout un secteur qui existe, les régimes d'exception dans les sociétés comme les nôtres. Et puis, ces différents projets-là se sont accompagnés de démarches de consultation qui sont importantes dans le temps. La première, ça a été le forum citoyen qu'on a organisé en 2020, mais qui a été suivi par la suite d'un sondage qu'on a mené auprès de la population, un peu comme vous l'avez fait vous-même, et puis de la tenue de la Grande Assemblée sur le droit à la justice en 2021, qui est suivi d'un sondage sur l'intelligence artificielle qu'on a mené il y a 1 an et demi. Et tout ça, en fait, nous a fait réaliser jusqu'à quel point, si on veut modifier la place des citoyens, les placer au centre du système de justice et du système juridique, on doit le faire avec eux dans le cadre de perspectives qui sont peut-être plus ambitieuses que la modification des lois une après l'autre. C'est ce qui nous a amené vers le projet des États généraux sur le droit et la justice. Alors pourquoi ce projet général, des États généraux pour, je ne sais pas si la traduction en anglais suit, c'est un processus sur 2 ans dans notre cas, au cours duquel on réfléchit à toutes les dimensions sur lesquelles des modifications peuvent être envisagées. Ça oblige à aborder très largement, sur des thèmes très larges, la nature des systèmes de justice et des systèmes juridiques dans lesquels on est, et puis Alexandra qui exposera un certain nombre des thèmes sur lesquels on est amené à travailler. Et évidemment, pourquoi on le fait? On le fait parce que modifier les lois dans une perspective, je dirais, segmentée, loi par loi, à la fois c'est long, hein, mais je dirais de façon plus importante, ça ne règle pas certains problèmes inhérents au système juridique. Un de ces problèmes-là, c'est que les acteurs travaillent chacun de leur côté. On dit travailler en silo, c'est un problème éternel. C'est vrai dans le système de justice, c'est vrai dans le système juridique dans son ensemble. Les citoyens sont peu impliqués dans les réformes du droit et de la justice, et c'est de plus en plus vrai maintenant, alors que les discussions, par exemple, en commission parlementaire, lorsqu'une loi est déposée, ces consultations-là ne comptent pratiquement plus aucun particulier, aucune personne individuelle dans la consultation, et puis ils sont menés à tambour battant sur une très courte période, de sorte que les lois sont adoptées entre la première lecture et la sanction sur 28 jours, 24 jours, ce qui permet aucune délibération et qui fait que finalement les citoyens n'ont pas leur place dans les discussions concernant les lois qui les régissent. Beaucoup d'idées existent et beaucoup de pratiques ont été développées, notamment dans le milieu communautaire, des pratiques qui favorisent l'accès au droit et l'accès à la justice, mais ces pratiques-là ne sont pas généralisées et nécessitent dans certains cas qu'on reconnaisse leur intérêt, que ce sont des pratiques nouvelles qui fonctionnent, qui amènent finalement les juristes beaucoup plus proches de l'activité des personnes dans leur cadre courant de vie et qu'il faut réussir à utiliser ça pour l'étendre à l'ensemble des intervenants dans le système. Finalement, un des problèmes aussi qu'on a, c'est que les solutions sont toujours abordées à la pièce. Dans le domaine du système de justice, du système judiciaire, c'est particulièrement le cas, là. On change un truc ici, on change une juridiction là. C'est fondé sur aucune perspective générale et on sentait le besoin de développer cette perspective-là. Pendant ce temps-là, le reste des problèmes se maintiennent. 80-90% des gens, selon les enquêtes, disent qu'ils ne comprennent rien au droit quand ils lisent. 78% croient qu'il n'y aurait pas le moyen de faire affaire avec un avocat. 74% considèrent qu'ils ne pourraient pas payer plus que 100 $ de l'heure pour le service d'un avocat. Or, il y a seulement 4% des praticiens qui chargent moins que 100 $ de l'heure. Donc, ça rend tout à fait et tout bonnement impossible l'accès à un professionnel. Ce sont ces problèmes-là auxquels on est confronté et auxquels les États généraux vont chercher des solutions. 3 objectifs vont évidemment rendre le service juridique plus accessible. Alors, évidemment, on ne parle pas du système du service judiciaire ici, on parle du service juridique. Le service juridique, le fait d'avoir droit à être accompagné par des juristes, par des professionnels ou des non-juristes qui servent d'intermédiaire du droit quand on en a besoin. Le deuxième, simplifier et accélérer le processus de justice. Les problèmes de délai pour le traitement des causes sont des problèmes universels, mais si on ne réfléchit pas à qu'est-ce qu'on peut faire aujourd'hui avec ça, on continuera à les avoir dans les prochaines décennies. Finalement, développer une culture juridique chez les citoyens. on vit dans des États de droit où les citoyens, en définitive, connaissent très, très peu la réalité des rapports juridiques. Qu'est-ce qu'un consentement? Qu'est-ce qu'un contrat? Quelles sont les obligations de base d'une personne en société? Il n'y a pratiquement aucune formation là-dessus dans les écoles, et puis les citoyens sont très peu informés de ça. Donc, on a un problème de culture collective du droit. On a développé 3 principes pour asseoir les propositions qu'on fera à la suite des États généraux. Le premier principe, c'est que tout doit évidemment être fondé sur l'accessibilité au droit et à la justice. Le droit doit être compréhensible, mais la justice doit être accessible également. L'efficacité, toute proposition qu'on va devoir faire dans le cadre des États généraux doit connaître une effectivité là, réelle, que ça doit atterrir dans la réalité. Et finalement, l'opérationnalité, il faut que ça s'inscrive et qu'on sache comment et dans quelle, je dirais, séquence on va pouvoir amener ces modifications-là. Alors, les États généraux sont construits là-dessus et structurés particulièrement sur des thèmes dont Alexandra vous parlera maintenant.
Merci. Je vais revenir aussi sur la structure un peu plus loin, parce qu'il y a beaucoup de monde qui sont mobilisés dans le cadre des États généraux et qui ont permis d'identifier 8 thèmes prioritaires. Donc, je les expose rapidement, étant donné le temps limité, mais on pourra revenir, si jamais vous avez des questions, sur certains des thèmes qui sont d'ailleurs déjà lancés, donc des groupes de travail qui vont se pencher sur l'éducation juridique, l'information juridique, les enjeux financiers aussi de la justice, tout ce qui touche aussi l'évolution de la profession, l'accès aux services juridiques, la démocratisation dans l'élaboration des normes. Et ici, on veut vraiment impliquer les citoyens, les personnes dans l'élaboration, la simplification des lois, ainsi que l'intelligence artificielle et technologie, mais vraiment au service du droit et de la justice, donc pour les citoyens. On se penche aussi sur l'action communautaire en matière de justice. On a d'ailleurs organisé tout récemment un forum sur le sujet qui a réuni plusieurs organismes communautaires du milieu juridique, mais aussi des organismes qui offrent pas nécessairement de services juridiques, mais qui collaborent avec les organismes communautaires justice. Et le dernier thème, la justice administrative, donc qui est très proche en fait du quotidien des citoyens, des personnes qui ont des enjeux juridiques. Sans oublier, donc un projet très ambitieux, un grand chantier aussi sur l'institution judiciaire, la procédure civile et la justice participative. Voilà ce qu'il y a des thèmes. Maintenant, comment est-ce qu'on va y arriver? Première étape, la mobilisation. Donc, c'est un projet vraiment collectif qui réunit l'ensemble de la communauté juridique, le milieu communautaire, les chercheurs, les praticiens, les juges. Une déclaration commune a circulé, a été signée par plus de 220 signataires là, de tous les milieux. Et on continue bien sûr cette mobilisation tout au cours des États généraux. Deuxième étape, construire les solutions. On est rendu à cette étape. Les comités, les groupes de travail sont en train de se composer et ils vont mener des recherches, des consultations publiques qui vont pouvoir prendre différentes formes, que ce soit des entrevues, que ce soit des sondages, que ce soit des forums, comme je le mentionnais tout à l'heure. Et on veut vraiment accorder une place importante à la participation citoyenne, tant sur les groupes de travail que pour la consultation au niveau des pistes de solutions à identifier, mais aussi à valider empiriquement avec eux. Voilà. Et à chaque fois qu'il y aura un rapport de produit, il sera rendu public au fur et à mesure. Donc, restez à l'affût. D'ailleurs, on va voir bientôt le rapport synthèse sur le forum sur l'action communautaire qui sera rendu public sous peu sur notre site web. Nous allons également présenter donc les recommandations et avant de les présenter tout au long de la démarche, on va s'assurer qu'il y ait une rétroaction, donc toujours en consultant l'ensemble des parties prenantes sur les solutions, les recommandations qui seront proposées. Et à la fin de la démarche, nous allons organiser un sommet des États généraux dans le cadre duquel seront présentées l'ensemble des recommandations qui ressortiront des travaux qu'on entrevoit donc au début de l'année 2028. Comme Pierre l'a mentionné, c'est une démarche sur 24 mois. Je ne sais pas où je suis rendue au niveau du temps, mais il y a une suite. Il me reste 2 minutes. Il y aura une suite. Donc, on va également faire le suivi de ces recommandations pour s'assurer qu'elles soient implantées. Voilà, peut-être un dernier mot ici rapidement sur la structure donc des États généraux. Il y a un comité de soutien, comme je vous disais tout à l'heure, également un comité directeur qui s'assure de la priorisation des différentes thématiques qui seront abordées avec le soutien d'un comité de coordination dont l'Institut assure le secrétariat, ainsi que les différents groupes de travail thématiques et le comité de suivi dont j'évoquais tout à l'heure. Alors, on est rendu à la toute fin, mais je tiens quand même à vous présenter les membres du comité directeur, qui est composé tant de juristes, d'avocats, de notaires, de personnes qui travaillent dans le milieu communautaire et de chercheurs, bien entendu. Certains sont d'ailleurs présents aujourd'hui. Je tiens à souligner la présence d'Anne-Marie Santorineos, qui est sur le comité directeur, Jérémy Boulanger-Bonelli également, qui est impliqué dans l'organisation de cette conférence. Et oui, et aussi donc des membres, comme vous voyez, issus de générations différentes. Donc, on implique beaucoup les jeunes aussi dans le cadre de la démarche. Voilà, si vous avez des questions, il nous fera plaisir de répondre à vos questions. Merci.
Okay, thank you very much. I think maybe we'll hold questions until we'll do our. Well, hang on. Sorry, gotta take that off. That's talking to me while I talk to myself. I think we'll hold questions on everyone's panel maybe until after we hear from the Law Commission of Canada, and then we'll have a bit of a Q&A before we move on to the workshop section of today's panel presentation. So with that, I will hand things over to the Law Commission of Canada. Thank you.
Yeah. Thank you very much, Leah and Nye, and thank you to our colleagues from Alberta, from Quebec. It's always inspiring, I think, for the Law Commission of Canada to keep learning from the experience and longer experience that our provincial counterparts bring to the table. I'm going to start with some quotes from a short essay entitled "Sometimes It's Better Just to Fix the Dock," an essay in a collection called Lessons of Everyday Law by Rod MacDonald, the first president of the Law Commission of Canada, who served from 1997 to 2000, and whom some of you may know as an access to justice scholar, teacher, and leader in Canada. And it's kind of nice, Laura actually set this up by talking about the image of the broken bridge, because here we go. So this is Rod. Each summer for the past 20 years, I have spent a week vacationing at a cottage built by my grandfather and now owned by my sister, brother, and myself. In the spring, we have the pleasure of surveying the latest episode in the long-running and unequal struggle between the forces of nature, the power of ice at breakup, and our capacity to imagine new and better ways of reinforcing and anchoring our docks. Each summer vacation, as I set about repairing the winter's damage, I cannot help thinking about whether to rebuild the docks from the ground up, and if so, how best to do it. Thinking through dock repair requires thinking through where the ice is going to move next. It also requires worrying about whether the dock is placed in the right position in the first place. And it compels one to ask whether the current design of the dock is appropriate. It is usually at moments like these that frustrated cottagers begin to question whether it is even necessary to have a dock at all. The analogy between rebuilding docks and reforming law is very close. One may well be able to solve a little problem in one corner of the law with a legislative amendment that has the effect of displacing the problem elsewhere. This is the everyday business of policy development, but it is not clear that it requires an agency like a law reform commission or institute to undertake this kind of task. On other occasions, it may be necessary to rebuild or even reconsider the foundations of a regulatory regime. Here is where the tough stuff of law reform occurs. And I think we've just heard some examples from Alberta and Quebec. For here it is necessary to ask whether an improved statute, a better permanent dock, or a new statute, a replaceable dock, or perhaps no statute, getting rid of the dock, is required. In these cases, one seeks to understand the forces of social change, the character of ice flows, and to direct them where possible in a manner that dissipates and channels them productively, that preserves the dock and transfers the stress harmlessly. The business of meaningful law reform is all about this kind of creative inquiry. It is about how we have designed and built the law to date, and about what options we have for meeting the dilemmas and challenges of social change. So Rod MacDonald in this essay, as you can hear, raises questions about whether, when, and how to replace, to repair, to redesign, to renovate, to rethink. And these are all common questions, the kind of everyday work of people who do law reform work and people involved in access to justice, and in particular, people-centered justice within that framework. How do we assess needs? How do we craft and experiment with our responses to those needs? How do we serve people? How do we pursue justice? How do we dream and repair at the same time? As the current president of the Law Commission of Canada, I am tasked and have been tasked for almost 3 years now with reconstructing and reintroducing and reimagining the Law Commission of Canada, which, as some of you may know, was in hibernation for 17 years between 2006 and 2023. I started by looking back to look forward, and that is the theme of this little presentation that I will do with Amelia Souffrin, a fellow at the Law Commission of Canada this year. Together we will try to demonstrate briefly the kind of intergenerational and constantly evolving work of law reform, and to suggest that that is shared with the intergenerational and evolving commitments to people-centered justice that we find across this country. To do so, I turn to what you see in front of you. You're probably wondering, what does the slide have to do with what she's talking about? But here we go. I introduce you to a report published a little over 25 years ago. So 2025 marked the 25th anniversary of the publication of the first report of the Law Commission of Canada in its first stage of existence. At the start of the LCC's existence, in the fall of 1997, the Minister of Justice asked the Commission to initiate research and consultations about the processes that we have in this country to deal with institutional child abuse. The resulting report that you see up there, entitled Restoring Dignity, Responding to Child Abuse in Canadian Institutions, was published 3 years later in 2000 and provided a constructive and wide-ranging framework of analysis aimed at both governments and the general Canadian public. The Commission articulated several questions. It asked what constituted total institutions for children, whether characterized as special needs schools, child welfare facilities, youth detention facilities, or residential schools for Indigenous young people. It asked about the range of actors and actions and practices that were experienced or that had the impact of acting in ways that were experienced by young people as abuse. And it asked about the spectrum of human needs that emerges through a process focused on the perspectives of survivors and an accompanying commitment to ensuring information and support for survivors. The report is striking as an example of law reform. It is not framed as concrete advice or detailed recommendations easily turned into directives for legislative drafting or revision. Instead, it offers an extensive exploration of coexisting responses to institutional abuse available in Canadian law and society. I'll list those responses in a moment, but it starts, and I think this is particularly significant for the people-centered justice community, by identifying 8 human needs: remembrance, acknowledgement, apology, accountability, access to therapy, access to education, financial compensation, prevention, and public awareness. And then working from those needs, it identifies mechanisms that exist in law and society to respond to them: criminal justice, civil liability, children's advocates, public inquiries, community initiatives, compensation schemes, truth commissions, ombudsman offices, and official apologies. And so, for those of you who don't know this report, I obviously strongly encourage you to take a look at this 25-year report. But I want to underscore, and Amelia will pick up on this in a moment, that this first report combined law reform in the mode of repair of past harms with law reform in the mode of articulating a vision for the future. Let me now take just a minute to share what I think will be a surprising example of the impact of a law reform agency by looking at a law classroom. This isn't a traditional way to measure the impact of a law commission's work. But in the fall of 2001, so just after this report was published, my first-year students in tort law began their study of law in general by learning about the experiences and claims of survivors of Canada's Indian residential schools. I invited them to reflect on the range of human needs that I just read out to you, those 8 needs that may result from injury, by reading excerpts of this report. For most of the students at the time, and of course this changed and has changed from year to year, this was the first time they had heard anything about residential schools. Every September from 2001 to 2022, I welcomed students to law school in the same way. The first thing they read is a Law Commission of Canada report. And with that, I'm going to turn, what they do with that report is then I divide them into groups, assign them different responses, so a Truth and Reconciliation Commission, community-based initiatives, formal apology, criminal justice, civil liability. And without really knowing anything about those responses, they think about how they are particularly strong in responding to the needs, the human needs that that the Law Commission identifies. And with that, I'm going to turn to Amelia to jump forward in time and connect this to ongoing work and a varied and perhaps surprising way of understanding the work of a law commission.
Thank you. Comme mentionné précédemment par Shana, l'année 2025 a marqué les 25 ans de la publication du premier rapport substantiel de la Commission du droit du Canada. Et c'est un rapport qui a vraiment contribué à préparer le terrain intellectuel, juridique et social ayant mené aux travaux de la Commission de vérité et de réconciliation plusieurs années plus tard. Donc, cette année a également coïncidé avec un anniversaire connexe, celui du 10e anniversaire du rapport final et des 94 appels à l'action de la Commission de vérité et de réconciliation. Donc, on se rappelle ici des travaux de la Commission de vérité et de réconciliation et de ces appels à l'action qui étaient vraiment des recommandations concrètes qui visaient, dans un premier temps, à reconnaître les torts et les conséquences causées par les pensionnats autochtones et, dans un second temps, à promouvoir des changements concrets dans nos institutions, et que ce soit au niveau institutionnel, gouvernemental, organisationnel ou même citoyen. Et donc, la coïncidence de ces 2 anniversaires est vraiment venue offrir à la Commission du droit du Canada l'occasion de souligner la pertinence continue de ces 2 rapports. Et donc, en septembre 2025, la CDC a lancé l'initiative Dialogue intergénérationnel en droit. Donc, on peut voir ici l'appel de soumission. Donc, c'est une initiative qui avait pour objectif d'appuyer une série de dialogues au sein de facultés de droit canadiennes entre des étudiants en droit et des personnes porteuses de savoir issues de différentes communautés autochtones. Donc, ces dialogues sont venus explorer les traditions juridiques autochtones, les progrès et les défis qui ont été identifiés au cours des 10 dernières années depuis la publication des appels à l'action, ainsi que les enjeux et les possibilités qui se profilent à l'horizon pour les générations futures. Donc, 3 dialogues ont été tenus à l'hiver 2026, soit à l'Université de Victoria en Colombie-Britannique, plus près d'ici à l'Université d'Ottawa et finalement à l'Université de Montréal. Donc, j'ai assisté au dialogue tenu à l'Université de Montréal en mars, un dialogue qui a été organisé en majeure partie par des étudiants en droit, membres du comité droit autochtone à la faculté de droit de l'Université de Montréal, et bien sûr avec le soutien des membres du corps professoral de la faculté. Donc, le dialogue a réuni des membres du public, des enseignants, des étudiants en droit de premier cycle, donc au baccalauréat en droit, qui étaient inscrits au cours de droit des premiers peuples. Et bien sûr, il y avait aussi 2 personnes porteuses de savoir de la communauté Ganawagé, donc située au sud-ouest de Montréal. Donc, les participants étaient tous assis en forme de cercle. Je pense qu'on a une image. Donc, ils étaient vraiment tous assis comme autour d'une table ronde pour avoir cette discussion. Et l'une des personnes porteuses de savoir a ouvert l'événement en parlant de la signification que représentait ce dialogue selon elle, et je la cite. This discussion is just a beginning. The purpose of the circle is to make sure that we look each other in the eyes. The eyes are the windows of the spirit, and in a circle, everybody is equal. Donc, j'ai trouvé cette phrase vraiment évocatrice puisqu'elle désigne l'idée selon laquelle la réconciliation n'est pas un événement ponctuel. C'est vraiment un processus qui est continu de transformation sociale, juridique, mais aussi relationnelle, qui vise vraiment à établir des relations entre autochtones et non autochtones qui sont fondées sur la vérité, la reconnaissance des torts, le respect mutuel et la responsabilité. Et donc, pour plusieurs étudiants qui étaient présents dans la salle ce jour-là, ce dialogue était vraiment une première opportunité d'aller au-delà de la salle de classe, de la doctrine, de la jurisprudence, pour vraiment entendre des perspectives et des façons différentes de comprendre le droit, la justice, les relations humaines. Les 2 personnes porteuses de savoir se sont montrées extrêmement généreuses dans le partage de récits qui provenaient de leur tradition pour vraiment exemplifier des principes clés dans leur compréhension du monde. Pour ces jeunes juristes qui étaient présents dans la salle ce jour-là, c'était vraiment une occasion aussi d'acquérir une compréhension du droit qui est centrée directement sur les personnes qui sont concernées, leurs histoires et leurs narratifs. Et donc, pour conclure, je vois que le temps est écoulé. Nous avons choisi cet exemple pour plusieurs raisons, mais pour revenir au thème du panel et de cette conférence, la réconciliation exemplifie beaucoup de notions qui sont parallèles avec les travaux de réforme du droit. Donc, c'est vraiment un processus continu de transformation de relations et ça devient aussi une condition essentielle pour l'accès à la justice. Finalement, cet exemple démontre aussi la continuité des travaux de la Commission et l'exemple des dialogues intergénérationnels démontre aussi comment est-ce qu'on peut continuer de revitaliser des rapports qui participent justement à ce devoir de mémoire et de transmission de savoir entre des générations. Merci.
Okay, thank you very much. Before we open it up to maybe some questions from the floor or comments, if there are any, Nye and I have a question for the panelists to consider, please. And my question, in the interest of time, I had 3, I'm going down to 2. My question is going to be, what opportunities do you see for collaboration between your law reform agency and other organizations working on improving person-centered justice in Canada, given that the theme of this conference, or one of them, is breaking down silos? So opportunities to break down silos between law reform agencies and other organizations. To the panel. We're in silos. Happy in your silo? Anybody? And Nye, our co-moderator, would like to take a stab at this one.
I'll start off. Anyway, there's extraordinary opportunities for law reform agencies or research organizations in the justice system generally to collaborate. And I would say it's not just academic Community collaborations, that's important. It's academic, institutional, community collaborations. It's also collaborations with organizations that are traditionally not within what we consider the kind of the classic access to justice communities. And it's all project-based. So we're doing a lot of work around policing. We've consulted with a lot of police agencies. Not classically the people who you talk to if you're thinking about policing issues from an access to justice perspective. Also, depending upon your project, you got to break out of the legal box to break out of the justice system box. There's a lot of experience, there's a lot of information, there's a lot of contacts, networks, in other areas beyond kind of the traditional conceptions of the justice world that are dealing with the same issues that we are, but from a different perspective, perhaps with a different vocabulary, different experiences, different lessons, different communities, whatever you want to call it. There are a lot of people working on the same issue, whether it be in family law or whatever else. And we can learn from them just like they can learn from us. So you gotta forget about the box, forget about the arbitrary distinctions between us and them and us and social services, however you want to describe it. You have to cast your field really, really widely. And when you begin to cast your net a little more broadly, you realize that a lot of people are concerned about the same issues that we are from an access to justice perspective, perhaps not described in those terms, but they want to develop solutions for a lot of the same communities we do, and it can only help to collaborate.
Thank you. Thank you, Nai. Any other panelists want to speak to the possibilities of collaboration?
I'll start off with the typical first-year law school answer is that it depends. So for us, it depends on the project basis. So we're sort of like serial specialists. So right now, we are collaborating with some other agencies who work in areas regarding residential tenancies. We also had a law prof come to us and say, I've just come back from my sabbatical, I've written this book, there's this problem that needs to be solved with respect to family arbitration. I'll do the work, can I work with you? Great. We also had somebody in a similar position, they wanted to update the personal property security legislation in Alberta, which is kind of technical lawyer's law, but if someone is coming to take your car away because you haven't made a car payment, and yet you did, there's also access to justice issues there. So we collaborate, I guess in a serial basis in different areas of the law. So that also, unfortunately, is something that makes it hard for us to collaborate together as law reform agencies because we've got different projects going on at different times and we just don't usually have those priorities that overlap.
Okay, thank you. Oh, go ahead, Laura.
Sorry, if I can just jump in. Is this working? I just had an example from a recent project that I thought kind of picked up on what Sandra was talking about. In our residential tenancies project, we've been trying to connect with people who are dealing with things on the ground. And we had meetings to talk about data because we'd identified that there was a real lack of data. And so we thought this was an opportunity for cooperation and collaboration with agencies. We reached out, we organized 2 in-person meetings and a Zoom meeting, and had these great conversations because we hoped that we would find, who had data and then we'd be able to share it. Now, unfortunately, this maybe picks up on the challenges part. What we learned is that of all these people in the room, none of us had data. So we identified a gap that unfortunately we haven't been able to fill yet. But I do think it has built a really interesting conversation and relationships that will help us in the rest of the project.
Okay, thank you. I think Amelia?
Oui, donc je vais juste ajouter brièvement la perspective de la Commission du droit du Canada. Donc, la collaboration avec d'autres organisations et d'autres institutions est un peu centrale au volet d'engagement et de rayonnement de la Commission. Je pense que ça part de la perspective que, oui, on est centré sur la réforme du droit, mais on est conscient que la réforme du droit se passe ailleurs, en dehors de la commission. Et donc, je pense qu'un des engagements, des initiatives majeures qui permettent cette collaboration avec d'autres organisations pour nous, c'est le support aux conférences. Donc, on a une plateforme qui nous permet d'identifier des organisations, des institutions qui cherchent à avoir un soutien financier pour donner certaines conférences. Et donc, avec ce soutien qu'on est capable de leur offrir, ça nous permet de collaborer avec diverses organisations qui, justement, travaillent dans le domaine du droit et de la justice.
Thank you very much. I think now, unless there's anything else from the panelists, yeah, go ahead, Pira.
Okay. Alors, oui, la question des rapports, la question c'est un peu, est-ce qu'il y a un risque d'enfermement? Est-ce que les instituts, les commissions du droit ne sont pas susceptibles de connaître une forme d'isolement par rapport aux citoyens, alors que, normalement, notre mission nous amènerait à les mettre au centre de toutes les réformes qu'on fait? Et je crois que ce risque-là, le risque de l'isolement, c'est un risque continu. Il n'y a pas d'institution qui est à l'abri de ça. C'est un défi perpétuel. Il y a quelques solutions à ça, évidemment. Nous, on a trouvé une forme de solution dans l'interdisciplinarité parce qu'en mettant des chercheurs qui travaillent sur beaucoup d'aspects différents, on est obligé d'intégrer la dimension, la réalité des citoyens comme une exigence de nos travaux. Ça nous est rappelé par les sociologues, ça nous est rappelé par les anthropologues, les politistes, on n'a pas le choix. Et donc, ça nous amène à pas oublier cette dimension-là. Je pense que l'autre aussi dimension, c'est le caractère public des rapports. Il faut qu'ils soient lisibles par tout le monde. Mais ça, il faut comprendre que ce sont des conditions de rayonnement de ce qu'on fait vis-à-vis des citoyens. Mais nous, je pense que notre exigence, en tout cas, il faut aller vers plus loin que ça et être irradié par les citoyens. C'est-à-dire qu'il faut que ça aille dans les deux sens. C'est pas seulement dans nos préoccupations paternalistes par rapport à la condition des personnes, mais qu'on soit, nous, plus ou moins la cible de leurs demandes, d'une certaine façon. Et ça peut prendre toutes sortes de formes. Bon, nous, on perpétue les enquêtes, puis les recherches, les groupes, les forums. Et puis, notre objectif, quand on arrive là, c'est pas de venir livrer la bonne parole. On s'assoit, puis on écoute. Et on réfléchit à partir de ça. Donc, on se laisse carrément irradier. Il y a un risque à ça, hein. Vous savez que les demandes sont beaucoup plus importantes que notre capacité de répondre. Mais c'est la seule façon, je crois, de ne pas se couper, nous, des citoyens. C'est d'être plus ou moins le récepteur de leurs demandes. Mais là, il faut qu'on crée les conditions de ça parce que les citoyens, ils n'auront pas à dire à un institut comme le nôtre ce qu'ils pensent. C'est nous qui devons créer les conditions de cette prise de parole. En tout cas, c'est ce qu'on essaie de faire. Mais c'est une pratique qui doit constamment évoluer. Il y a des moyens extraordinaires maintenant pour faire ça. Les communications électroniques, numériques rendent possible beaucoup de choses qui n'étaient pas possibles avant. Et avec le temps aussi, on a développé des projets sur la participation publique à la définition des lois, comment ça peut se faire, dans quelle mesure ils peuvent être impliqués. Et s'ils sont impliqués dès le départ, ils ont plus de chances, oui, d'être présents à la fin. Et je crois qu'il faut aussi réfléchir dans ces termes-là. Ça nous amène à une autre conception de la démocratie.
Thank you. Sorry for my delay in picking up the mic. There's a bit of a delay between the translation. Thank you very much. I think at this time, maybe before we move into the last little workshop portion, I'll invite any comments or questions from the floor, but also no pressure. If you don't have any, we can just move straight into the putting you to work portion of the panel. Okay. Oh, go ahead. You have to go to a mic so you're recorded for the official recording. Oh, okay. Go ahead.
Can you hear me?
Yep.
Okay, hi. Yeah, so I want to touch on the process of legal law reform. So I'm going to trigger some nostalgia with those of us who had to take jurisprudence in class. So, for example, some jurists will say in one jurisdiction, for example, just giving a hypothetical, minors can drink alcohol, and then in another jurisdiction, you can only drink alcohol after you're 18, right? So, in deciding what laws to reform, what processes do you have to go through to make sure that if you are reforming the law, to make sure some people cross-section of society is able to access justice, how do you make sure that it doesn't impact other people who might be impacted? Or how do you make sure you don't create problems for other people? Or how do you make sure other people do not lose access to justice because you are creating, you are helping other sections of society access justice? So I would like to understand how the process goes. I teach at the University of London. I'm a professor there. But I would like to understand how law reform is done, for example, in Alberta, and what the processes, what are the processes that you have to do, or the Law Commission of Canada, what processes do you have to go through, or do you go through to do due diligence to make sure that other sections of society do not lose access to justice? Thank you.
It's a tricky question. Most law reform agencies tend to develop project selection criteria over the course of time because they weren't given much guidance by the agencies that set them up. So, for example, both the Law Commission of Canada, which kind of builds a little bit for its jurisdiction on the model of the Law Commission of England and Wales, is to keep under review all of the law. I mean, that's just impossible. So, people initially, a lot of people working in law reform, they were guided by their own personal preferences, which of course isn't appropriate either because this is public funds. So over the course of time, agencies have developed criteria to try to determine, firstly, is there a defect in the law that needs to be addressed? So, quite often we get people saying the law in this area needs to be fixed. And it doesn't actually. It's just someone who doesn't like the way the law is, but the law is working perfectly well. So, when we get these suggestions, we try to figure out what is the nature of the defect. And to come to your point, we also want to consider who is going to benefit from remedying this defect, but also who is effectively benefiting from the status quo. Because when we change the law to make it better for someone, odds are that it might make it worse for someone else. So say, for example, this was a comment that we got when we were looking at the project that Laura referred to on bringing in property division for common law couples. I'm not sure how, but our report got picked up by a forum of gun owners in Alberta, which every once in a while made you kind of look at the door going, no, we're fine. And it was a very interesting discussion that this forum had. There were a lot of comments along the lines of, well, this is just another way for women to get men's stuff. It's not, this is an equitable division of family property. There was that embedded idea in there that, it's all the men's stuff. And the committee sort of moderated itself and saying, look, this goes both ways. But for us, ultimately, what was the solution there is that the defect in the law was in its default. So it didn't matter whether or not we made express rules or we left the law as it was. There was still that mechanism for, to take the gun owner example, women to get men's stuff. But the default was it relied on common law principles of unjust enrichment and constructive trust, which is such a complicated area of law that it should never be the default. If that has to go to court, it's probably a 10-day trial. And as we've seen, no one can afford those types of rates. So even though some people would have been, to their view, it would have been a detriment to them to change the law, they were actually also in a better place because we put in, with the assistance of the government picking up our recommendations, a clear default set of rules that people could then opt out of rather than people opting into this terrible default of constructive trust and unjust enrichment.
Thank you. I'll turn to our second question.
Thank you. I would love to have the panel's thoughts on the notion of legal expertise itself, and if you think the sociology of the legal profession has tensions with some of these ideals and aspirations that we've been talking about, simplicity, accessibility, and so on. Professeur Noro, vous dites qu'il ne faut pas s'isoler des vrais citoyens, and there's always this chance of lawyers being disconnected. Well, what is the appropriate role of the lawyer or the jurist in this reform process? And are you wearing your hats as lawyers who want to center citizens and so on, and as part of this conversation, or is this a different hat, if you will? And how do you navigate this possible tension between the vested interest of a legal profession that's defining feature is having the knowledge and expertise, and then wanting to make that knowledge and expertise in a certain way? The IQ RDG mentioned interdisciplinary approaches, having political scientists, other social scientists, basically non-lawyers involved in the same process. How do we reconcile that with our hat?
I can give. I'll give a short answer from the Saskatchewan perspective. I think my commission, anyways, we have 6 or 7 commissioners. We would definitely consider the somewhat narrow range of our expertise in project selection at the outset. So if we get a project proposed to us that seems to have very much a strong public policy component, where our commissioners know they're not going to have expertise, we're not going to take that project on. And we're probably different from some other commissions in how we operate on that way. So the Law Reform Commission in Saskatchewan tends to pick projects that are lawyer's law. Is there a statute that needs to be fixed? So it's kind of considered then. And then the other thing that I think all of us do, all of our law reform agencies do, is really broad consultations. So we're seeking input from the public via survey, via focus groups. There's a variety of things that we all do. And then that input would be considered by the commissioners in making recommendations, or working groups, or however our organizations structure our work. So my quick 2 answers would be project selection and broad consultations. And then also other organizations too would have a diverse set of people on their board as well. So those are my 3 answers, I guess.
Yeah, I mean, I'll just quickly say, like, lawyers have expertise and experience, but it's not exclusive. And a lot of, people and organizations have experience and expertise. And further to Leah's point, the way to do a good law reform project, in my view, is to ensure that your project, the people involved in the project, and the research techniques you use during the project reflect, a broad, cross-section of different experiences, different areas of expertise, because people have different experiences with the law. And, lawyers are good at the technical stuff. Like, what does the statute technically say? What does the case say? That's important. What are the procedures? That's important when you're dealing with a justice system issue. But it is by no means the only perspective on an issue. And a good project, in my view, in fact, triangulates, for lack of a better phrase, between, depending upon the project, a broader cross-section of people, organizations, experiences, techniques, and comes up with, and then has a similarly thoughtful process to try to mediate as between all these different, experiences and expertise, is to come up with, what is hopefully a thoughtful, common solution across these different sectors.
Thank you. We'll do one final question, and then we'll move on. Thank you.
Just first of all, I want to thank all the panelists for sharing your expertise and your work with us today. It was illuminating and wonderful to hear about. I've been reflecting over the last few days, as I usually do, about how often we talk about access to law when, in fact, we seem to be focused on access to the legal system. And that seems to be rather true. And then Laura's comment around how access to the legal system won't get you justice if the laws themselves are unjust. I thought that really resonated. So in that vein, I'm thinking about kind of the challenge put forward by Justice Karakatsanis around shifting the dialogue from rights to common good. And I'm curious, in that regard, with respect to your work, when you think about law reform, to what extent would you say your mandate might include legal system reform as opposed to law reform. Is that something that you actively think about or consider as part of your work? And I'm curious if that's something you think could be considered part of the work.
I'll answer quickly from the Saskatchewan perspective and let my colleagues speak for themselves. So we all do have different mandates. And so the Law Reform Commission of Saskatchewan, like Manitoba, is one of the original statutory agencies that still derives our authority from the Law Reform Commission of Saskatchewan Act, which does speak to keep under review all laws of Saskatchewan with a view to modernization, simplification, and one other thing that I should know off the top of my head that I don't. So from our perspective, if staying within that mandate, we wouldn't take on legal systems reform. Some of our recommendations might have implications potentially that we would consider, but we would stay in our narrow lane. But some of the other organizations like Ontario and BC have a much broader mandate, so I can't speak on behalf of them. And IQRDJ also has a very broad mandate too. Do you want to go ahead?
Oui, je pense que c'est une question centrale. Puis pour répondre à ça, il faut se demander, du point de vue des citoyens, le droit c'est quoi? La justice c'est quoi? Autrement, on va l'interpréter, la construire à partir de ce qu'on a construit institutionnellement comme professionnel, de ce qu'est la justice. Et là, à ce moment, on tombe dans un certain type de justice. Et le droit, la loi, alors que peut-être que pour les citoyens, le droit, c'est pas seulement la loi, ou c'est du moins les normes par lesquelles on régit nos rapports entre nous pour éviter de s'entrechoquer. C'est très simple, mais à partir du moment où on le définit comme ça arrête d'être un problème uniquement de loi et de règlement. Ça peut avoir un impact direct sur notre conception de la loi, mais ça touche d'autres dimensions qui sont celles dans quelle société ou dans quel système de relations on veut vivre. Et c'est déterminant dans notre conception de la justice, soit c'est le système judiciaire, soit c'est la justice celle que les gens la conçoivent. Et qu'est-ce que la justice? Très peu de gens peuvent répondre à cette question, mais tout le monde est capable de reconnaître une injustice quand il est devant cette injustice-là. Et en général, c'est quand il a été traité d'une façon qui est différente de celle qu'il croyait être la bonne façon d'être traité. Et quand on comprend ça, on comprend toute la dimension interactive à la fois du droit et la justice. On comprend un peu quel est le lien entre le droit et la justice, parce que souvent, on ne voit pas ce lien-là. Là. Alors que la justice, dans beaucoup de cas, on ne la reconnaît pas parce qu'elle survient tous les jours lorsque notre relation avec quelqu'un correspond à ce qu'on s'attendait, à la norme qu'on s'attendait, au droit qu'on s'attendait voir respecter. Et donc, il y a une relation complètement intrinsèque dans la vie quotidienne entre l'idée de droit et l'idée de justice. Tant qu'on ne comprendra pas à quoi sert la loi dans la perspective des citoyens, et tant qu'on ne comprendra pas c'est quoi la justice sur le plan des rapports quotidiens, ben oui, on va travailler d'un côté sur des systèmes et de l'autre, on va oublier en fait qu'est-ce que sont les attentes sociales des citoyens pour lesquels ce droit et cette justice au départ avaient été conçus.
Thank you very much. I am now going to take over for the last 3 or 4 minutes here, just so we can do the very last thing. And we're going to go 3 minutes over because we started 3 minutes late. So I hope that's okay, because lunch was 5 minutes late. So we'll just continue on with that trend. We were asked today to maybe design a bit of an interactive piece to this. The Q&A was great and also interactive. So we're not going to spend very much time on this next part here, but I just wanted to introduce it to you. I have some copies of the draft guiding principles up there. We were told that one of the themes of this conference is breaking down silos. So to that end, we really wanted to hear from you. There's so much expertise in this room, and expertise and wisdom. And so we thought one way of doing that would be to get some feedback from you on a set of draft guiding principles that we think could guide anyone involved in law reform with the goal of advancing access to person-centered justice. And I should say, I luckily married a farmer, so had some non-stock photos of grain bins that I was able to use. Which was one benefit. He can also fix everything, which was another benefit. But unfortunately, his farm was the only farm that did not have oil, so I did not benefit from that aspect of the farm. But I do appreciate these free photos. So the draft guiding principles, I'll turn to them now. This is something that Nye and I have developed based on a review of academic articles on law reform and A to J, and a review and comparison of A to J BC's AAA measurement framework, the Action Committee's 9 Justice Development Goals, and the OECD Toolkit for Access to Justice and People-Centered Justice Systems. And we're also grateful for the input we received from Brie Lohenberger, Strategic Advisor to the Action Committee. So yeah, we would love to hear your feedback on this. I know we're running out of time. You have the paper in front of you. You can read some of them on the screen too. We've basically come up with 3 overarching principles. Yeah, go ahead.
Yeah, and we're just going to lay them out. There's a lot of detail, and we're asking for input at the end. But in the interest of time, I'm just going to read through them, lay them on the table, and if anyone has any questions or comments, please contact us. So, 3 draft principles to govern law reform agency: project selection, project process, project reporting. Number 1. Commit to undertaking projects that promote access to justice in their respective jurisdictions or nationally, which could mean, not exclusively, could mean promoting legal rights, including but not limited to charter rights, human rights, procedural fairness, responding to new or important unmet or emerging legal needs, promoting fair and equitable access to law. There's a little bit more detail, but that's the gist of it. Principle number 2, commit to applying access to justice principles and analysis in our work, including ensuring the communities most affected by the law or legal issue are meaningful involved at important stages of the project, using multidisciplinary and empirical research techniques, and then working collaboratively with others towards issue identification and recommendations and knowledge mobilization. And then finally, 3rd general principle, ensuring law reform agency materials, reports, and recommendations are publicly accessible in clear, plain, and inclusive language and formats. So these are the operating principles, governing principles that guide a lot of our work anyway. However, as an organization or collection of organizations, we want to instill these, kind of bake these into our respective mandates. But we can't do it alone. We're lawyers, need to get lots of input. And we are putting it out there to you and to others to try to fine-tune this, make sure we've got the right tone, tact, substance, and that it informs our work meaningfully going forward. I'm sorry.
So our 2 kind of big questions are we missing anything? And does anything need to be clarified, refined, or expanded? We'd love to hear your thoughts on that. If you have time to take a look at them, come find me or Nye or any of our panelists or any other law reformers that are here in the crowd. Come and talk to us. And with that, I will conclude and say thank you. We're very appreciative to have been invited here. Looking forward to hearing from you. And yeah, thank you for coming today.